How's it going, everybody? So we just got an interesting update on the Franklin Armory Title I lawsuit. So let's talk about this. But real quick before we jump into this video, if you think that the state of California needs to stop infringing on our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, USCCA. Through your membership, you get training, education, and self-defense liability protection. So if you carry a concealed carry firearm, you have firearms, I highly recommend you look into carry protection. I recommend USCCA, and you can find a link to them down in the details section. So if you're not aware, the Franklin Armory Title I was a product put out by Franklin Armory. Franklin Armory has a lot of weapon systems that are geared towards California and all the ridiculous laws that we have here in the state. These products include things like the Franklin Armory CA7, the CA9, the CA11, those pistols that are classified on the handgun roster in the state of California, so we can actually purchase them because we have the safe handgun roster. There was another product that they came out specifically for the state of California, and that was the Title I. The Title I was a firearm that was considered not to be a rifle, pistol, or shotgun, but instead an other. And therefore, since it was an other, it could have specific features on it that other types of rifles or pistols or shotguns could not have on it because of California's ban on so-called assault weapons. Now, that changed last year in the passing of SB 118, which specifically targeted Franklin Armory and their Title I. And in that whole process, I had talked about that a lot on the channel. And one of the things that also happened after that was a mass action lawsuit that a lot of people signed up for on behalf of themselves and also on behalf of Franklin Armory. Well, we got an update from Franklin Armory today, not necessarily on the mass action lawsuit. I want to make that clear. This is not on the mass action lawsuit. Instead, this was a prior lawsuit they had filed in the state of California against the Department of Justice. And that one was kind of being held up because of a demur. And I assume a lot of you aren't familiar with what a demur is, but it is a motion in the state of California essentially saying that although you assume all things that are factually alleged in the complaint on behalf of Franklin Armory, the state of California is saying, although we assume, let's just assume all those things are factually true, there is still not a valid claim. So the state of California files this demur saying, hey, they alleged all these things. Let's just say they're true anyways, but anyways, this motion would fail. That is what a demur is. Well, we got an update that the state of California in a superior court has actually denied the state of California's demur. And so I'll read to you this breaking news that came out from Franklin Armory. It says, breaking: Los Angeles judge permits $30 million lawsuit to proceed against California Department of Justice. And this was issued today. It says, today, Franklin Armory Inc. and the California Rifle and Pistol Association announced that Honorable James Chaffont, judge in the Superior Court of California for the County of Los Angeles, recently ruled that the petitioners in Franklin Armory et al. The California Department of Justice may proceed on their writ of mandate against the Department of Justice. A writ of mandate is an action against a state entity or an agency, essentially saying that what they're doing is improper and that the justice system or the judges to actually issue this writ against them and enforce them to do the proper procedures. In this case, it would be actually to add that drop-down menu on the DROS system for an other, which the state of California failed to do, continued to fail to do for many years. Therefore, Franklin Armory could not sell the Title I to us, even though it was legal prior for them to do that. The lawsuit filed by Franklin Armory Inc. and the California Rifle and Pistol Association on May 27th of 2020 alleges causes of actions for, among other things, declaratory relief, traditional mandamus, and violation of public policy for the actions taken by the Department of Justice and their representatives to block the sale and acquisition of lawful firearms, including the Franklin Armory Title I. The remaining actions, including those actions seeking damages over $30 million, have been deferred until after these initial claims have been heard. And then the next section goes on to say that the Department of Justice knew that they did not add and failed to add that drop-down menu so that Franklin Armory could transfer these firearms and sell them to people in the state of California. And then there's a quote from the court. And so here's what the court said. It said, in the court's June 3rd, 2021 ruling on the demur, the court stated that, as far as a mandatory administrative duty, I think that the penal code is relatively plain that the Department of Justice have to create an electronic transfer record or some other form of transfer record, which is required under Penal Code Section 28160 for all firearms. A lawful weapon has to be subject to a transfer somehow. The DOJ has the right to exercise discretion as to how that occurs, but it cannot prevent lawful weapons from being transferred, which is what the Second Amendment complaint alleges it's doing, and doing so as an underground regulation. So The court is pretty much saying that the demur by the state of California fails because there was a proper claim that, and factually, if you take everything as true, there was a proper claim that can move forward because the state of California is failing. And if you take it as factually true that the state of California failed to add a drop-down menu and failed to actually have a way in which these lawful firearms could be transferred, then the claim could proceed forward. Now, this has a long way to go. This is not over, but it is good news that this lawsuit is moving forward and that potentially the state of California will get smacked down once again by a court because they failed to do what they are supposed to do in this case, which is actually lawfully transfer something that is a legal firearm that we should have been able to purchase and possess in the state of California. And what they did is they failed to add that drop-down menu so that they later could actually pass some sort of legislation in SB 118 to classify these firearms as assault weapons in the state of California and just outright ban them. So, and here's a quote from Jay Jacobson from Franklin Armory. He states, "This is the first step in vindicating the rights of our customers and our rights to sell lawful firearms without arbitrary and politically motivated interference from those who are charged as gatekeepers of our fundamental rights. It is sad, however, that such a clear duty of the Department of Justice requires a lawsuit to enforce." And I agree, it is sad. And then at the very end of this notice, there is a statement about this moving forward. And I'll read that for you real quick. It says, "The Department of Justice now must answer the petition and the case will at least move on to the next stage of litigation. Though this case is far from over, both Franklin Armory and the California Rifle and Pistol Association are grateful for the court's ruling and consideration of California's complex firearms laws." And like I said, this isn't the class action lawsuit that a lot of us signed up for last year, but instead this is the state action that Franklin Armory had against the Department of Justice. And at least this one is moving forward, and at least a court agreed with Franklin Armory and our side that the state of California, it did do something, and at least it moved past this demur, but it has to go to the actual trial, the actual litigation. This wasn't on the actual merits of the case. So there's going to be some other things that happen, and there's going to be other motions probably filed, and it's got to go to trial and go through all those traditional procedures. But there was kind of a roadblock with this demur, and at least the Franklin Armory claim moved past that. So if you guys have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, if you guys like this video and like support the channel, one of the best ways to do that is to like, comment, subscribe, and make sure to hit that notification bell because that helps the channel analytics, helps us spread the word about the Second Amendment, also spread the word about 2A news like this that is going on in the state of California and nationwide. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars and this nation will be maintained by armed scholars.